Planet Green Trees, episode number 188. Let's talk about hemp, we're calling it. I'm your host, Michael Komorn. Beside me to bring you the most entertaining and up-to-date and informative content of what's happening in Michigan surrounding the Michigan medical marijuana and the marijuana reform movement. It's Chad from the Birmingham Compassion Club.
We have launched.
The editor-in-chief of the Compassion Chronicles, the weekly news anchor of Planet Green Trees, the one and only Rick Thompson.
Hello, everybody.
And, of course, the one and only producer of Planet Green Trees, also sometimes affiliated with Third Coast Compassion Center, and the producer and in charge of bringing all the great guests, including the musical guests tonight. I think you heard those. And, of course, it's the one and only Jamie Lowell, Third Coast Compassion Center.
Hello.
We got a great show as always. We're going to be talking about the Michigan House members in Lansing holding public hearings to discuss allowing the industrial hemp cultivation in the state of Michigan. The battle continues for the Green family, even after overcoming criminal charges and major challenges with Child Protective Services. The Ann Arbor Medical Cannabis Guild hosts a fundraiser at the Rush Street Bar in Ann Arbor tonight, the National Patient Rights Association. The group responsible for advancing the patient-friendly bills in the state legislature. And yes, Weed Can, theater production concerning the issues of decriminalizing cannabis, will play throughout the month of March at the Planet Ant Theater in Hamtramck. Joining us to explain all that tonight will be Steve Sharp of Michigan NORML, board member. He's been working with lawmakers to introduce an industrial hemp bill. And he's been attending and participating in many of the public hearings on the issue. We're going to hear from Steve. Also, Steve Green of the Cannabis Crusaders and Human Solution will be joining us. Steve's a regular on our show, bringing us up-to-date court information. And we're excited to have him back on and explain to us what's going on now and why he's being called the ringleader of the cult of marijuana. Also, Robert Snyder, legislative liaison for the National Patient Rights Association. She'll be attending the fundraiser for the MPRA, hosted by the Ann Arbor Medical Cannabis Guild. Also expected to be attendance of the organization's Daryl Stavros of Third Coast Compassion Center, Attorney Dennis Hayes, and, of course, Representative Jeff Irwin, local government leaders and area supporters. I did see a piece on with Rep. Irwin exclaiming his support for the bill that he introduced for decriminalization. Also, Sean Hanlon, co-writer and director of Yes, Weed Can, the original musical comedy that examines the complex issues of decriminalizing marijuana by telling the stories of three friends, a grower, a user, and a bureaucrat, and of how weed suddenly suspiciously came to be illegal after centuries of use and acceptance. I'm going to rant in a little while. We're going to have a lot of other current events, and as I said earlier, Rick with the news and input from everybody. But I want to give a big thanks to all the supporters of the show, my dear friend Dewey and Pam, for all your support and being there, helping us get the job done. The Michigan Medical Marijuana Association, MichiganMedicalMarijuana.org. I want to thank all the moderators and administrators who help monitor the forums and evolve the conversation about medical cannabis. Komorn Law, 1-800-656-3557. The Marijuana Ranch, 313-422-5281. Our good friend Dr. Kumar Singh, Greenlight Clinic, 248-390-0574. Dr. Singh, of course, substantiates the gold standard of certifications, as we talk about every week on the show, and I just want to remind everybody that patients, caregivers need to be more aware of, responsible for the patient's charts. Big shout out to Bob and Tori. We know that Tori's still in hospice and Bob is taking care of her. We wish them well, and our best to our hardest working Thetford Township trustee, Eric Gunnels, who I know is advocating diligently in his region for medical cannabis reform. All right, so there's a lot of things to talk about. I was going to do a rant on hemp, but I think we're going to get into that a little bit about Steve. Steve calls in. I don't want to... but I do want to talk about something that's constantly happening. It's one of the things daily that I'm discussing with clients that come in and want to be, they want to understand the law. They want to be able to not get in trouble, and they want to know what they can do to not get in trouble. And I'm going to call this beyond compliance counseling. And it starts with the premise of why do I even have to say this or discuss this? But the backdrop of what I believe much is going on in Michigan is that you've got a evolution of a concept of an industry in Michigan. Great need for a new industry in Michigan, and Steve Sharp's going to explain one of them. But there's a whole driving force of desire for people to be in business for and provide services to a growing number of individuals who are using medical cannabis as an alternative to other medications. And I mean, let's just be honest. I mean, it's the trend and the direction of things is moving in a place that it's probably going to be legalized at some point, and people are trying to align themselves and be part of it. And there's nothing wrong with that. It's forward thinking. It's just a resistance from it comes in ways that can be punishing to people if things aren't all in order. But I've been describing this element, this entity that exists, was more like a dinosaur that is soon to be extinct, but is ravaging the landscape, trying to find any prey that it can in its last years before it ultimately can no longer survive because it's too hot or too cold or just the environment has changed. And that is the driving force. That's really what it is. It's like, we should be running around outside and having no problems playing in the lakes and the rivers, but there's these dinosaurs that may come around and, just gobble you up and make prey out of you. But that's the only reason why we're having these conversations. I mean, the people of the state of Michigan voted overwhelmingly for patients and caregivers to be protected. The legislature has had its opportunity to amend the law. They did. The law still remains intact, and now there are discussions and laws that are moving its way towards some method of regulation in a business context. So all of that is in play, but as we stand here in the shadow of what may be great reform or some other adjective type of reform, still the act is the act, and it's important to understand some of the factors, even for Section 4 protections, that I think are problematic and need to be revisited and discussed. One is the concept of usable or unusable material. And the concept that I speak of here is that for the act to work, for a gardener to be able to cut a plant down and hang it up and dry it, in that moment, that may be an amount of marijuana on that stalk attached to the plant, wet, that's going to weigh more than that individual can possess. And I know that the prevailing view of the medical cannabis community has always been, well, that's not usable, therefore it doesn't count against me. I just think it's important to mention this because a lot of people still are in that mindset, and I'm not saying that the decisions that have established themselves provide any clarity on this exact issue, and I do know that many courts still recognize the concept of usable materials, potentially not. But I think when you ride this thing all the way up the flagpole, we have to be able to, the act's got to be workable. So there's obviously problems. I can tell you about cases where someone's, harvested 40 plants and the patients are over and trimming them and they're not in the room, they're no longer plants, and they stuff them in bags and weigh them, and it's a lot more than 2.5 ounces. Because the first place you start is no one says you have to grow 12 plants. And if you're outside of Section 4, you got to defend yourself. You better explain why you have 12 plants and be able to justify it. And I say all that because being able to control the amount of marijuana to keep it within a usable, the definition of usable material, which is the dried bud or leaf of the flower, and seemingly harvesting a plant when it's wet would put it in a category that it's not part of usable material. It might be something else and cause you problems. So it's important that we mention these things. I think one of the solutions, which seems ridiculous, I've said it to a few caregiver consultations recently, and the reaction wasn't ridiculous. I mean, I wonder what the feedback would actually be if, just to be safe, let's say that instead of cutting the plant's roots off, you pull it out of the ground and let it hang and dry. No, but I'm just saying, it eliminates a lot of the problems. Do you agree with that, critic from the left?
I don't know.
All right. How about anybody else? Anyone else?
See gray areas everywhere.
Well, I'm just saying, I'm not talking about, when I'm speaking is from a lawyer's perspective. I'm giving advice beyond compliance counseling, meaning every person around would think that's ridiculous. What do you mean I can't dry my plants? It's not usable? But I'm saying don't have that ambiguous discussion. Or harvest, not all at the same time.
I mean, certainly whole plant drying, I think, is an important concept at this point. And it's just because we've seen so many issues with the police not really understanding what they're seeing when they see a cut-apart plant that's cut apart into branches. They don't know whether they're looking at one plant or many.
Beyond compliance counseling is what we're doing right now. Because it shouldn't be necessary, but it is. And it's only because the predator still exists. And that seems ridiculous.
They're looking for non-compliance, just like when you get pulled over and they look at your license.
That's my
This
spiel.
is what I've heard.
And I'm just kidding. It's true. That's my spiel. All right. So the point is that although this may seem workable, these are important principles to think about, or at least be aware of it. You know, the master grower would have to be somebody who's actually perpetually growing and drying, curing at a time when it's going to the patients before they're taking the next ones down. Again, plant count, you know what the line is. You stay back from the line. Dead plants, clones, they're all going to be thrown into the fray. So that's the story on usable and unusable material, and I guess we should even take it a step further in regards to the Carruthers opinion and the issue of medibles and the ridiculousness of that. I mean, right now, I think that opinion was the motivation for the amendment
5104, House Bill 5104.
Allowing for some new measures and some measurements and numbers to be able to make the law workable. I mean, the discussion I always envisioned of the Carruthers opinion before the Michigan Supreme Court would be, counsel, stop fighting with the prosecutor and answer a question for us. How do we make this workable? You know, the numbers that we have within the Michigan medical marijuana, how do we make it workable? Now, I know, Rick, I said earlier, it's got to be a number. But I agree. I think the fact that the maker of it can define that. I think that should be, even though I don't know that's a reality.
Workable would be that they figure out how much THC is in it using their extremely expensive labs that the taxpayers paid for, but they're unwilling to do that.
And therein lies the problem. All right, so, of course, the other issue, which seems ridiculous and has become just such a laughable but punishing way for individuals to find themselves in the system, is the concept of the enclosed lock facility. This has been taken to a level of unworkableness in a lot of situations. I've heard officers testify that someone could have come onto the property, climbed up the fence, and crawled into the roof and over, which means that and therefore it's not enclosed and locked because someone might have access to it. Someone could get in there. And in order for them to do that, they would have to commit a series of crimes. And the suggestion would be that in order for you to be in compliance, you've got to protect against criminals.
You've got to have a moat. A moat now is the new compliance.
But
beyond compliance.
I even argued the other day that accessibility to the plants, and this is not to be taken as advice, but I do believe the ultimate decision on that has been mischaracterized and misused by the law enforcement community, because the issue was not in the enclosed lock facility whether someone had access to the plants. That really was not the ultimate issue, because in the Ballsma case, the building inspector broke into the building. So he had access, according to the way that they're describing a non-enclosed lock facility in these other cases that I mentioned. But the reason was because Ballsma was possessing more plants than he was allowed to under the Michigan Medical Marijuana Act, and therefore he's in violation of Section 4. How could it be said if he's handling 40 plants that he has no more than 12? Which is ultimately an issue of possession and an issue of amount. I mean, I'd even surmise that there could be, I'm not suggesting it's not legal advice, but just the way it's being played on court, that an individual theoretically could be in the same room as somebody else when they're allowed to possess 24 plants, but there's only 24 in there. And or The other individuals, a lot of says 24 plants, there's only 24 in there, and 12 of them belong to 12 to one and 12 to the other.
Unlitigated. But again, another area that has been unfortunately abused by law enforcement, finding the loophole, finding the way in which it seems to be or appears to be not locked, and then of course taking it down and calling it illegal. Now, and of course the final one in terms of what the Supreme Court has given us guidance for is on the transfers, oftentimes misunderstood, oftentimes misstated what the opinion really meant, but we're talking about People versus McQueen, that the caregiver is only allowed to transfer to one of his 5 patients, her 5 patients, and receive immunity from what would otherwise be described as illegal behavior in the public health code. However, transfer to a 6th patient, 7th patient, 8th patient, 50th patient is defendable under the Michigan Medical Marijuana Act, Section 8. But if you're going to do that, know in advance the challenges that you're going to have. Make sure that the interaction, the point of medical transfer, involves a patient who has a bona fide relationship with their doctor, that the discussion is about medical cannabis and the treating of the patient's specific condition, that certain things should be learned during the conversation of how the patient uses it, how frequently they ingest, and what strain and why. And but still, there's no guarantees. The law is being abused right now by the most recent Court of Appeals opinions, but I'm betting that the Supreme Court's going to do us right. And I think with that being said, that we've covered a little bit of the intended goal here, and we're going to get into some other stuff when we come back. But this was, of course, Beyond Compliance Counseling as a rant. And we're going to take a quick break and listen to Planet Green Trees. The call-in number is 347.
Hey, what's going on, guys? I'm Sammy Jarouche, and welcome.
Whoops. The call number is 1-347-326-9626. Take a little break and be right back. You'll listen to Planet Green Trees.